a cell phone on you, if you, at this time, please put that on vibrate, quiet, off, or don't bother everybody around you, whatever setting that is. That's for just everybody's courtesy. Can everybody hear me?
Up a little bit.
Need more volume. How's that? Okay, cool. I have a tendency to wander away from the mic a little bit, and I don't like to hold one and walk around, so we're going to leave it fixed, and we're going to try to speak from here. At this time, I'll introduce to you Mayor Larry Chester, City of Fort Payne. He's going to do our invocation, and when Mayor Chester gets through with that, I'll introduce some other folks here, and then we'll have some opening comments. We'll start into the program. We are going to take questions, but they will be at the end of the program, and we are going to take a break at 6:45 for around 15 minutes, and then we'll come back and finish. So we anticipate being out here around 8 o'clock. I appreciate the crowd, the attendance, and I know your interest is several fold, so we'll try to address all the questions that you have, hopefully during the presentation, so we won't have a lot of questions. At this time, Mayor Chester.
Thank you, Wade. I'd like to say welcome to everybody. We've got a good crowd here tonight, and I guess I could say check your guns at the front, but everybody would be seeing if they were loaded, I guess, so we don't do that. But anyway, we're glad to see everybody, and I know it'll be an informative session. All right, let us pray. Our Heavenly Father, we thank you for this day, and thank you for the opportunity we have to live in a country where we can express our opinions and gather undisturbed. And we thank you for the safeness that you give us, the freedom that we have. We ask you to go with us throughout this meeting, and as we return home tonight, go with us, watch over us. In Christ's name we pray. Amen.
Thank you, Mayor. At this time, we got a few elected officials here. Judge Steve Whitmire down here, our district judge. And Judge Whitmire, as you'll see when we get into the presentation, actually has a role in this new law. He's had that handed to him, so he's going to have to deal with it. Circuit Judge Jeremy Taylor is over here on my left. Police Chief Randy Bynum, City of Fort Payne. City Councilman Red Taylor, Gerald R. Any other elected officials here that I haven't seen yet? Okay. What I'd like to start off with is just a few opening comments here to try to put somebody at ease. And then I'm going to introduce the district attorney and the sheriff to you, let them have some comments, and then we're actually going to do a PowerPoint. But what I want you to understand up front is that we're not here as a group trying to tell you how to mind your business or take care of your business. What we're trying to do is give you some information, factual information as we can possibly put out to you about the new law in Alabama related to firearms, and it is Act 2013-283. This bill started out as over 150 pages. It was condensed down to 38 actual pages, and it will be even less than that when they codify it and take all the verbiage out that is old, antiquated, or been taken out. So when we get into the program, when you see a line of script up there with a line through it, that's the old law that doesn't count anymore. You've all got a handout that is this PowerPoint. We felt like it would be easier to keep up with, so we've given everybody a packet. In your packet, you actually have a sheet of paper that gives you the Secretary of State website and directions on how to go find the actual law in total, and you can print it off and read it for yourself. We don't have the whole law in total to go over tonight. We're going through the parts that are relevant. If you have a question about something we don't cover, then we'll get to that at the end of the program. But we're trying to cover everything that is relevant to us as citizens, business owners, homeowners, shoppers, and defense of your home and property, if you got those issues. So we wanted to try to get this information out as soon as we could. But the problem we've been having is there's still quite a bit of argument going back and forth between the Attorney General's office and some other agencies about how some of this is interpreted. So it is still a fluid situation. And some of this, truthfully, will be finally decided by lawsuits. Somebody's going to have to sue somebody over some of this stuff to actually set a precedent. So what we're going to try to give you tonight is our information that we've received through the training we've been through, actually go over the law. We don't want to take anybody's guns or gun rights away from them. We are all pro-Second Amendment citizens and public servants. What we want you to do is safely and legally carry your weapons if you're going to. And understand that with that comes quite a bit of responsibility. And if you're going to carry a weapon and carry it legally and carry it safely, to what extent are you willing to use that weapon? Are you willing to shoot and kill somebody if you have to? And if you're not, you may need to rethink what you're doing. So we want you to get the information that you can, take this home, digest it, do your own research. You'll see that early in this presentation. We encourage you to do your own research, because this Alabama law is not contradictory to federal law, but there are some federal laws that come into play that you have to be familiar with also. So we're going to cover some of that also tonight. At this time, I'd like to introduce to you Sheriff Jimmy Harris. He'll have some comments for you before we start, and then he in turn will introduce District Attorney Mike Odell.
Thank you so much. I shouldn't have said so much at Rainsville. He used my whole speech, and that's what he just said. But my chief deputy's here, Michael Edmondson. I don't know where he's at, right up here. He's waving, he's running the camera, doing something. Then we had the girls out front. Helping was Melissa Mason, Shannon St. John, and Nina Haney was out there. And Ricky Dog Higdon, y'all probably know him if you've ever, well, probably none of y'all's been to jail, but if you've ever been down there, you remember him. But I noticed we did have one person that's running for representative, Billy Hodges. Are you here, Billy? Right here. He's running for a House seat. Is it 24? Yes. Okay. Is anybody else running for office? I know everybody wants to be recognized. Anybody running from office or running, whatever. But I really do appreciate everybody coming out and giving us the opportunity to speak tonight. Wade does all the reading, and the district attorney answers all the questions, so I just get to stand up here. But like Wade said, this is a work in progress bill. This bill started out over a year and a half ago. It was 136 pages long. There was a lot of associations that opposed some of the bill. The District Attorneys Association, the Sheriff's Association, the Police Chiefs Association, the League of Municipalities, and I always forget the last one, but there was 5 associations that opposed the bill in the whole length, but they narrowed it down to what we could live with. One thing I'll talk about just a little bit now is the pistol permit and the way we issue them and how it's changed a little bit before we go into PowerPoint. But we have got into Cobb County. They introduced Jeremy Taylor, Judge Jeremy, a few minutes ago, and when he was in private practice, right after I got elected, I asked him to help me write a bill to get the pistol permit for senior citizens for $1. So we're the only county in the state of Alabama that does that for 62 and older. And it took us 6 months from the day we sent it in to get it passed and get it on the governor's desk and get it signed. So I appreciate Jeremy doing a good job helping us get that done. And of course, Todd Greason and Lowell Barron, they pushed it through for us, and we were happy with that. But one thing that has changed is you can get a pistol permit now for 1 to 5 years times the amount of the pistol permit. If you're under 62, it's $25. So if you want to get one for 5 years, it's $125, or you can get one for 2 years and be $50. Or if you get it for $1, you can get it for $5 if you want to do it for 5 years. Jackie Bailey said he wasn't going to waste his money. He didn't know if he'd be here that long. He didn't want to give me anything extra. So, but you know, this 18 to 21-year-old or 20-year-old that we issue now, I've been issuing those for about 6 years now. Myself and the Sheriff of Etowah County, Todd Entrophin, we got together and we drew up a little permission slip. If you still lived at home with your parents, then we asked them to sign it. If they signed it and brought it back notarized, then we would give you a pistol permit if you wasn't still in high school. I won't issue one now if you're 35 years old and still in high school. I'm not going to give you a pistol permit. But we've been doing that. We're still doing it the same way. I think we've sold probably since August 1st. We've probably sold nearly 50, 20 and under that has bought pistol permits. And we've sold a lot of the 5-year permits and all. And I know, most people, I mean, especially in Alabama, especially in the rural county like we live in, most everybody has had a gun all their life, or they fool with a gun. And, I feel like that everybody needs to have a gun if they're legally qualified to have one or mentally capable of handling one. I think everybody needs to have a firearm, to protect your family, protect yourself. So, the open carry is, I'll explain a little bit different in it. What the open carry is you don't have to buy a pistol permit. Alabama's always been an open carry state. A lot of people didn't know that. But to have open carry, what you have to do is you have to have a locked box, the way we understand it. This is the way the Attorney General explained it to us. You have to have a locked box. You have to have your gun in the trunk of your car unloaded and the ammo in another box with the trunk closed. So that's the open carry. Then when you get to where you're going, you can pull over and open your trunk and load it up and put it on your side, tie it on your leg or whatever kind it is, and walk up and down the street. But if you get to a place of business that says no firearms permitted, then you can't go in that with that open carry. But the way we understand it with a concealed permit is that you can go in those places of businesses as long as it's not a school or something like that, and might want to go into that a little more when he speaks. But still thank all y'all for coming, and when it's over, we'll try to answer all your questions, and we'll be here till y'all get ready to leave. But thank y'all so much for coming. Great crowd. I think we're going to try to put on a few more of these, probably one on the south end of the county, one on the north end, and probably one around Dogtown, Ruham. I don't know, is that the same place? I think it is, and whatever. Some of them say I live at Ruham, and some of them says I live at Dogtown. So we're going to try to have one out there also. So if Mike and Wade will help me, we'll have a couple more of these. But I certainly want to thank Mike Odell for helping me with this and getting all this together and being here with us to be the legal advisor. I always tell everybody, I'm the sheriff. I'm not an attorney. I have to play one at work sometime, but I'm just the sheriff. So at this time, if Mike will come up and say what he's got to say, I want you to know I do appreciate you, though.
I'm just going to take a minute because I think we'd really rather get into the PowerPoint program, but do want to thank you all for being here. This is an important issue. It's one that we've been dealing with for years now, and although we don't like everything about this bill, I do like the fact that it spells out your rights and my rights to possess a firearm. One thing I really would like to stress to you is that hopefully at the end, and particularly when we take questions and we attempt to answer them, that you understand that if you're a business owner, we're going to give you what best interpretation we can give you of the law, but you really need to ask your corporate lawyers about how they want your policy at your stores to be. The other thing is that even though we all are blessed to have the Second Amendment that protects our right to bear and possess arms, God gave us common sense. And it's important for us to stress to you that even though you have the right to carry a gun, it may not be the best thing for you. If you're not proficient in it, if you don't know how to use it, if you've never been matched with a weapon, for instance, you ladies, maybe a .45 is not what you want to carry. So please remember that when you decide that you want to get a concealed permit or you want to carry it on your side, use your head. And remember that generally speaking, a gun is used for one purpose, and that's for your protection. And unless you feel like walking down Fort Payne or Rainsville or Geraldine, you need that weapon strapped to your side. It may not always be the best thing to do. So use common sense. Let's stress gun safety. And as we get on through this PowerPoint program, if you have questions, if you can write them down, that's only sometimes the way I can remember them. But we will endeavor to answer every question you give us. And if we don't know it, we're going to tell you we don't know it. So without any further ado, let's get Wade back up here.
Thank you, Mike. I appreciate Mike and his staff, what we've been able to get so far. We've been to several training sessions. Mike has tasked his group of lawyers that work for him with doing what research they could and trying to come up with some short answers to some questions. And so we've got a 4-page handout from the district attorney's office that kind of gives us some bullet points to go over. And part of this PowerPoint, I plagiarized it. I'll go ahead and tell you more. The last 8 or 10 pages are basically the work of Scott Lloyd. We just rearranged it a little bit. But if you'll turn in your hymnals here to page 2, it says Act 2013-283 became effective August 1st. That's when this new law actually became law. It is still referred to as Act 283. It will be codified, and what that means is it will be organized and made more neat, and it will be basically put in a form where it's easier to read, because when you get into this in a minute, if you hadn't already looked through your PowerPoint handout, you'll see that there's quite a few places where you've got a sentence and another sentence with a line through it, and then another sentence, and there'll be words that are in and out of this, so we're going to try to cover those where we make it a little more sensible to you. But once this thing becomes final and is codified, it will read as it needs to read in order. So as you look through this program here, you'll see some things that look like Greek to you a little bit, but just understand that it is a work in progress. And if you pull up that Secretary of State website and look at the actual law, it's 38 pages. It is in 13 sections. This is the actual law. If you pull it up, print it off, this is what you'll get. Again, it's Act 283. And I think we fixed the typo on the handout, so if you'll follow the instructions on the handout, it should get you straight to this law. Now, in developing this program, we spent the last several months trying to get educated up on some of the key points of this law. So in an effort to do that, the District Attorneys Association and the Sheriff's Association got their counsel. They kind of got together, hashed it out, and came up with an analysis of the law. So you've got a law that's 38 pages. We've got an analysis of it that's 58 pages long. The sheriff in Dale County, I believe, hired a retired ATF agent to do an analysis also, and his is 55 pages long on the same bill. So depending on who you talk to and which lawyer you reference something to, you may get the same answer twice or not. And not knocking lawyers, because God knows we all need them, but if you get 2 of them together, you're going to get a different opinion on 7 out of 10 things. These are all the federal statutes that are referenced at some point, either vaguely or not, in the law. There are 2 places in the law that specifically say that the sheriff cannot disregard federal law, but it doesn't tell him in the state law what he needs to do. It just says that he can't disregard federal law. So the sheriff is tasked with learning federal regulations also in this permitting process. So that's been fun to learn. There's even a provision in there where you can give aliens pistol permits. Well, I don't know about you, but I don't know anybody that's in this country that's not a citizen that needs a gun for any particular reason. So there are 4 provisions under federal law that they can have one, and 3 of those 4 have to do with being an official of a foreign government. So it's kind of hard for an alien to get a pistol permit in DeKalb County. He's got to have a lot of paperwork and the blessing of the consulate. In your packet, in these handy little hang-on-the-door bags here, or suitable for carrying in one hand, you have a state of the office sheet that tells you what our office has done for the last year. We do this every year. Then you'll have the Secretary of State information on how to find the law. And to show you that we're pro-democracy, you'll have 2 notices that you can post. If you want to post anything, one says firearms are permitted, one says they're not. That's strictly up to you. We're not taking a stand on that. That's a private property issue, and you as a property owner or business owner, that's strictly up to you what you want to do. We're not recommending anybody do anything. But what I will tell you when we get into the PowerPoint here is you'll see that unless you post your property, you don't want firearms there, then don't gripe if somebody comes in there with one. Okay? If you don't want them there, you have to post it. So that's what's in the packet there. We gave everybody the PowerPoint because it's a lot easier to follow. Feel free to write on that. That's yours. If you've got a pencil or a pen, feel free to make notes. If you got a question as we go through something, write it down. And then at the end, we'll take the questions at the end, because trust me, after 5 sessions of training between law enforcement and lawyers going through this, we learned the hard way. Don't take questions during the presentation. Wait till the end and take them all at one time, because we try to answer as many questions as we can during the presentation. If you'll be patient, stuff in section 6 will answer a lot of your questions, but we're starting at section 1. So be patient with us, and we're going to go till about 6:45, 6:50. We'll take a break, and what I'd like for you to do when we take the break is, if you would, in an orderly fashion, you can go to the lobby and get some drinks. We've got water and soft drinks out there. Restrooms are in the lobby, and also up on the mezzanine level, we have a women's bathroom on this side and a men's on this side. So we have a men's and women's downstairs and one upstairs. So those are there for your convenience. If you do have questions, hang around. When we get to the end of the PowerPoint, we're going to take a break. And those of you that don't have any questions or are suitably informed, you can feel free to leave. We'll give you about 10 minutes to get out, and everybody else calm back down, and then we'll start the questions. So we anticipate, hopefully, if all goes well, we'll give you the information you need, and we'll be done by 8 o'clock, 8:30 at the latest. So we will be taking a break in just a little bit. But the law, basically, Act 2013-283, did become effective August 1st. And like the sheriff said, as of August 1st, he's already sold probably close to 50 permits just to people under the age of 21. And there's been some question about that. When we get in the permitting process, we'll deal with that more. Why can somebody 21 have a gun? Can they have a gun? Can they buy a gun? We'll get into that when we get to that part. So just bear with us, and we will try to explain the law as we know it collectively, and then we'll go from section to section. So section 1, repealed. Next slide, there you go. Section 1 in the new bill. This repealed prior statutes that dealt with counties, municipalities, and political subdivisions which regulated firearms. This basically said the state of Alabama will now regulate firearms. Cities can pass some regulations, but they can't do anything that exceeds what the state of Alabama has determined is best for U.S. citizens. Now, a city can adopt the state law as an ordinance and enforce it as such if they want to do that. But it has to be word for word, verbatim. It cannot take parts of it that they like and parts of it they don't. If a municipality wants to take, or a county government wants to take this state law, Act 283, and use it as an ordinance, then they have to do it in total. They can't just take parts of it and enforce it, parts of it not. Okay? Section 2, this is one that comes into play here. This amends the law that is related to disorderly conduct. This is something that was used for several years if somebody wanted to open carry, and the sheriff hit on this. Alabama's been open carry for a lot longer than any of us been around. And open carry means that you can openly wear a weapon as I am. You can see it. This is open carry. Concealed carry would be if my shirt was over, you couldn't see it. That's the difference. Open carry means that you literally have your weapon open for somebody to see. It's not concealed in any manner. So in Alabama, before this law became effective, you could still open carry in public places. You could not go on private property. The law has changed a little bit on that. So we'll get to that when we get to 13A1152. But what was used by some people to keep people from open carry was a disorderly conduct arrest. If somebody came into a place and was wearing a gun and scared somebody, then they would call the police, and the police would come, and they could arrest you for disorderly conduct and put you in jail, and you would have to work through the system and take care of it that way. This new law specifically says that merely having an open weapon does not constitute disorderly conduct. You cannot be arrested for open carry if that's the only thing they want to try to arrest you for. So in this statute, it goes through the first four things there about what constitutes disorderly conduct: engaging in fighting or tumultuous behavior, unreasonable noise, and you got enough sense to read the rest of those. The one that's important is on the next slide, which says, and even obstructing pedestrian or vehicular traffic, congregating with other persons and failing to disperse after being asked to by a lawful order. And then it tells you that disorderly conduct is a Class C misdemeanor. A Class C misdemeanor is 3 months maximum and a fine. But C under that is what's important now. It shall be a rebuttable presumption that the mere carrying of a visible pistol, holstered or secured in a public place, in and of itself, is not a violation of this section. So who other than a lawyer put in the term rebuttable presumption? So what is a rebuttable presumption? Well, we put that on the next slide for you to try to make that as easy as we could. The major change is that wording, and it gives the defendant the presumption that they are not violating the law. Just merely wearing a gun openly is not a violation of the law in Alabama as it stands today. A rebuttable presumption is a presumption that holds good until evidence contrary to it is introduced. In other words, if somebody's wearing a gun, you've got to presume that they're okay with it. You've got to have evidence contrary to that to make an arrest for something. So merely wearing a gun openly can't get you arrested. If you're in an open place and it's posted and you go on that property and you're open carry and somebody asks you to leave and it's posted, if you don't leave, the most they can arrest you for is criminal trespass. There is no gun charge. Okay? So open carry is not disorderly conduct anymore. Specifically has been precluded. 13A1152. This is right out of the law, and you'll see some of the lines through the wording here. Except as otherwise provided, no person shall carry a pistol about his person on private property, not his own, or under his control, unless the person possesses a valid concealed weapon permit, or the person has the consent of the owner, or legal possessor of the premises. So there's three little things there. You can't go on private property with a weapon unless you have a permit. So if you get a concealed permit, and a lot of people say, well, can I open carry and then get a permit and still go on private property? Yes, you can. I've had one lawyer explain it to me this way. You're already presumed under Alabama law to be legal to openly carry. So if you buy a permit, you're also now legally permitted to conceal carry. And under this statute, you're allowed to go on private property if you have a permit, or the permission of the property owner, or the person in possessory interest on the property. If it's somebody that's renting or leasing property, they have a possessory interest in it, so they can give you permission to come on the property. You always had the right to be on your own property with a weapon, and there's no exclusion to that. That's still covered. You're still good on your own property. You can mow the yard wearing a SIG. I don't care. It's your property. That's still legal. You can go in public property wearing a SIG. Now you can go on private property wearing that SIG if you got a concealed permit. Okay? So that's pretty much 13A1152. 13A1170. This basically is the definition of crime of violence. There's one of the provisions in here that will preclude you from having a weapon, and crime of violence is specified as something that will keep you from getting a permit. So A defines pistol, anything with a barrel less than 12 inches. A crime of violence is anything that's in that whole list of things there that are basically common sense. Those of you that watch TV, you'll just have to figure out what mayhem is. I don't really put a lot of people in jail for mayhem and attempt to ravish. That's an old term. There's some things been in this code for 100 years, and they just leave them in there because they look good, I guess. But the trick to this is, down at the end there, you'll see that crime of violence shall also mean, along with those things listed there, it will also mean anything that's a Class A felony or a Class B felony that has an element of physical injury. So any Class A or Class B felony with a physical injury involved is also a crime of violence. And the distribution or manufacture of a controlled substance is a crime of violence. Or any sexual act involving a child less than 12 is a crime of violence. All of those will preclude you from getting a pistol permit, as well they should. So we go to 13A1173. 52 says you got to have a permit to go on private property. 70 tells you what a crime of violence is. 73 says, except on land under his or her control or in his or her own abode or his or her own fixed place of business, no person shall carry a pistol in any vehicle or concealed on or about his or her person without a permit. So there's some changes there. If you're going to be in a vehicle with a loaded firearm, you have to have a permit. If you don't have a permit in a vehicle, and I'm trying to make this as simple as I can, in a vehicle, traveling up down the road, if you're going to have a loaded firearm in it, particularly a pistol, you need to have a permit. That's the only way you can legally carry a loaded gun in a vehicle is with a permit. It's that simple. If you don't want to buy a permit, then you have the option of unloading your weapon, putting it in a locked box, in a secure area, outside of reach of the passenger or the driver, separate from the ammunition, and when you get to a place where you are allowed to carry it without a permit, you can get it out, load it up, and wear it. It's just that simple. But if you're going to carry a loaded weapon in a vehicle, you have to have a permit. If you go back and look at 52 versus 73, 52 says you've got to have a permit to carry it on private property. Doesn't say concealed. 73 says concealed. So there's some contradiction there. Well, which one is it? I go back to my lawyer friend who says you've already got the permission of the state of Alabama to carry it openly on public property. If you get a permit, you can carry it on private property. So if you got a permit, mere concealment is not going to be an arrestable issue here. If you got a permit and you conceal it, fine. If you got a permit and you wear it open carry. The one thing I will tell you is the sheriff believes that if you're going to buy a concealed weapon permit, you should go by the tenets of the permit, which says concealed on your person or in your vehicle. In your vehicle means you can lay something over it, a piece of paper, anything. You can put it down between your seat and the console, as long as it's out of ordinary view. That's concealment. It doesn't have to be locked in the glove box or the console or whatever. So if you got a permit, it says concealed. We're not going to arrest you for improperly carrying a weapon if you got a permit. Yes. Yeah. Sheriff said that's good concealment for your gun. Lay that over. That is concealment. It doesn't have to be locked up or put in. If you got a permit, and this is just common sense, and what we're trying to get you to understand is we're not out here being the gun police now. Some of these laws are federal regulations. I will not arrest you for a federal regulation violation. I can't do that. I can arrest you on state charges. I have to arrest you on charges that are either a warrant or something that happens in my presence most of the time. Sometimes I get exigent circumstances and I can get a warrant and get you arrested for something if it's a serious situation. But most of the time, if you're going to arrest somebody, you either got to have a warrant or it's got to happen in your presence. So what we want you to understand is we're not going to take anybody's guns away from them. We're not the gun police. We're just trying to get you to understand we don't want you getting in trouble. We don't want you to get into a confrontation with our officers because our officers are not going to go out and harass you for carrying your guns if you'll do it properly. And if you're going to carry a gun, be proficient in it, be safe with it, and know the law, and know what you're going to do with it. If you're not willing to go all the way with that gun, then you don't need to have it. You need to put it up, get it out of your reach. That's all common sense, folks, and that's what we want you to understand. I don't want to have to work a case where one of you goes out here at the gas station and gets harassed by somebody and pulls out a gun and shoots him. Because guess what? That's not justifiable use of deadly force if somebody's arguing with you. You have to be in fear of your life or imminent danger or death or injury to another person or yourself. Arguing with somebody doesn't constitute something that would justify you shooting somebody. You don't pull a gun and point it at somebody unless you're willing to pull the trigger and shoot them. You don't scare people off with a gun. You don't threaten people with a gun. You can be arrested on a warrant for menacing or reckless endangerment. If you pull a gun on somebody in an argument, they can go get a report and do a warrant on you for pulling that gun and pointing it out. That don't mean they're going to prevail in court, but it means that you get arrested and it's on your record until it's disposed of. So what we want you to do is stay out of trouble and understand what the situation is. So now we already see that 52 and 73 are contradicting each other. One says you got to have a permit, the other says you got to have it concealed. So I've just explained to you how we're going to act under those circumstances. But I will tell you, if the sheriff gets complaints that you're out here open carrying and using your concealed permit to do that, he's going to want to talk to you. And if he revokes your permit, he has to articulate a reason why. And I'll get into some of the reasons why here in just a minute. But we're not just gonna go out and harass people. We're not gonna be the permit police. We're not gonna be the gun police. We're gonna try to enforce the law, and we want you to be as safe as you can and understand what the law is. Under B there, except as otherwise prohibited by law, a person legally permitted, and that doesn't mean you got a permit, that means you're legally permitted or allowed to do something. But who does not possess a valid concealed may possess an unloaded pistol. So that goes to what we was talking about a while ago. If you don't have a permit, but you are legally allowed to have a firearm, you have to have it unloaded in your vehicle.
Ray, you might want to stress the fact that when it says in a locked box, that does not include a locked glove box or a console, but the law intends in that situation is in your trunk.
It has to be completely out of reach. If you've got it in your console between the seats, guess what? All you got to do is open it up and reach in there. If it's in the glove box, you can reach it. The intent of this is, if you've got enough sense to get a permit, you should be a good citizen, or they wouldn't give you a permit. You should be legally allowed to have a weapon and have enough sense to carry it and carry it safely, so you can have it loaded in the vehicle. If you don't have a permit, it's either because you can't get one or that's your choice. So if you make the choice to not have a permit, it's got to be unloaded, and it's got to be out of your reach completely, and not just you, but even the passenger. You can't have somebody riding with you that can get that gun out and load it and hand it to you. It's got to be out of the passenger compartment. So in a car, that's in a box in the trunk. In a pickup truck, that's in a locked box affixed to the vehicle, which would be a locking toolbox or something. So it's got to be in a box in the box. So everybody understand, if you got a permit, you're good. Carry a loaded weapon, but have it concealed. If you don't want a permit, then you got to go by the law. 131175, this is the permitting. And you can see that's a lot of verbiage right there, but about half of that's going to go away. But this is what's changed, some of the major elements of this section that have changed. The sheriff of a county, upon the application of any person residing in that county, within 30 days from receipt of a completed application and accompanying fee. You have to fill out an application and attach the fee. And in this county, it's $25 or $1 if you're 62 or older. So you fill out the application fully, attach the money to it, we do a check, and if it's done in a timely manner, we can give it to you that day if you're good and everything's fine. But that gives the sheriff 30 days to verify. And we had one today where one came back that had charges from 1969 that were felony. We don't know if those have been expunged or done away with. So we've got 30 days to find out and tell that person yes or no, you can have a permit. So within 30 days, the sheriff has to say yes or no. That's the law now. Shall issue has changed from may issue. Before, the sheriff could issue a permit based on his discretion. Now it says he shall issue unless he finds a reason to preclude you from having a permit. And there's quite a few reasons to do that. But it went from may to shall, and it says a qualified or unlimited license. That's gone now. Now it just says permit, and it goes into carry a pistol in a vehicle or concealed on or about his or her person from 1 to 5 year increments at whatever the rate is for that county. Calhoun County is $20. We're $25. Some are higher, some are lower. But if you want to buy a permit in this county and you're legally allowed to have a weapon and you're permitted to do so, you meet all the requirements. If you want to buy one and you're 48 years old, it's going to cost you $25. If you want 2 years, it's $50. And you can do the math. If you want 5 years, it's $125. And we'll send you a reminder in 4 years and 300 days that you're ready to come get another. That's going to help us a little bit because we send out annual renewals now to remind people your permit's going to expire next month, and we try to get those out in a timely fashion. So actually the people that are 62 and older, they're buying one permit now. It's good for 5 years if they give the $5, notwithstanding Jackie, who's a pessimist. But if you want to buy a permit and you're 65 years old, you can get one for 5 years for $5. Okay, so you're good to go. What we do, and I'll tell you right now, we lose money on every dollar permit. We lose about $1.40-something on every dollar permit because we had to charge something by law, a $1 issuance fee. The sheriff wanted to do it free, but by law in Alabama, you can't give something away for nothing. We had to charge $1, so we charge $1. Those of you that have the permits see them now. They're the new nice driver's license style card. It's got your picture on it. It's an actual legal photo ID. It's got your name and everything on it. It's got an expiration date. It's got the information on the back that basically tells you what you need to do and not do as far as carrying a weapon. Some simple things there. But when you get that permit, it's good as long as you follow the law and the tenets of that permit. So now you can get them for 1 year up to 5 years. You don't have to buy them in any set increment. That's strictly up to you. You can get them 1, 2, 3, 4, or 5. All right, another thing is, unless the sheriff determines that the person is prohibited from the possession of a pistol, and then we'll get into those in just a minute, what those prohibitions are, pursuant to state or federal law. That's where one of the catch-alls comes in now. The sheriff cannot disregard federal law. If you don't meet one of these 11 things under state law, but you meet one of the 9 things under federal law that keep you from having a weapon, we have to enforce that. We can't give you a permit to carry a weapon that you legally can't possess. Everybody understand that? If the federal law says you can't have a handgun, we can't give you a permit to carry it. We could be liable. So I hope everybody understands that. So pursuant to state or federal law. There's a phrase there also where it has a reasonable suspicion. Reasonable suspicion is a very broad term. And that could be basically what we try to apply to it is common sense. If you know somebody and they've had issues with something to the point where they haven't been to get mental treatment, but they've had issues and everybody in their family and everybody around them and everybody goes to church with them knows they ain't just right, and they come down there and want a permit, you can be denied, but you have to be able to write that down while you're denying them, that you have a justifiable cause for concern for public safety, or you have a reasonable suspicion that this person could injure themselves or others. So those are some things that are purposely vague to give the sheriffs an avenue to make sure that people that apply for a permit need one, okay? And if you deny one, you have to be able to write down why you're denying it. And then it goes to Judge Whitmire, and he's got 30 days to say whether he agrees with the sheriff or not. And he can overrule the sheriff if he feels like he has a little hearing and talks to the people and they bring friends or whatever, and they convince the district judge that they ought to be able to have one, he can order that they get one. But it's going to say ordered by the district judge, not given by the sheriff. So you're going to have a permit, but it's going to have on there in big black print, ordered by the district judge. So if you ever get stopped and somebody wants to see your permit because you got into trouble and you got a gun and you whip out that permit, they're going to probably ask you why the sheriff deny you one and the judge gave you one. So that raises some red flags right there and may cause you some grief on the side of the road. So we just want everybody to be safe and within the law. The 11 things that you see right here are in the state statute that will keep you from getting a pistol permit. And if you'll look, the first 9 are all dealing with mental illness or mental issues, all 9 of them. And you'll see that the term involuntary is in some of those. That means somebody has been sent to the nervous hospital against their will. And I'm sorry if you've got friends that have been in the nervous hospital. I'd just rather say that than the insane asylum or some. I've got relatives that have had conditions, trust me. But we all love our family and we try to pick our friends as best we can. But if you've had somebody that has been involuntarily sent for mental care, then that's what that means. Involuntary. It means that they went against their will. Now you can go check yourself in for mental evaluation if you've had a psychological episode or something and you want to go see if you can get some help. If you voluntarily go, then that's not in these 9. All of these have to do with being adjudicated, mentally deficient, or involuntary commitment to a facility. So if you got somebody that's had a bad issue, an event in their life where they went to get some mental health, then that doesn't in itself keep them getting a permit. But it's something that's probably going to have to be explained to take care of this number 11 down here, this cause for public safety. And that is starting with the permit holder. You want to give a permit to somebody who you feel may be a threat to themselves. And the sheriff is, for as long as I've known him, he's denied permits to people that come in there in the middle of a fight with somebody and say, look, I got into it with this guy yesterday, I need a pistol permit. He's like, well, when you calm down and get over that, we'll talk about it. I'm not going to give you a permit to go out here and shoot him and say I'll let you do it. You need to calm down, get out of the heat of the moment, try to work this out, and Lord knows all the domestic cases that we work, they'll be fighting on Friday, in jail on Saturday, and begging you money to get them out of jail, and they're back together Tuesday. So we try to take common sense, and there's a phrase in part of this that talks about how recent was the activity that you're dealing with as far as your application process here. Number 10 is falsifying any portion of the permit application. That will preclude you from getting a permit. And number 11 is caused justifiable concern for public safety. That is also a very broad term. On page 12 here, the next one. The sheriff shall take into account how recent anything under this preceding paragraph happened. In other words, are you still having a landline dispute with somebody and you're mad, you're down here wanting a permit so you can go out and shoot your neighbor? Y'all need to work that out before we start giving permits and stuff like that. So how recent did this activity take place that you're having an issue with? Once again, the sheriff has to provide a written statement of the reasons for denial and the evidence upon which that decision was based. Except as otherwise provided by laws of the state, a permit issued is good throughout the whole state. So if you get a permit in DeKalb County, it's good in all 66 other counties. Likewise, if you got one from Calhoun County, it's good here. Alabama also passed in this new act the fact that we are reciprocal with every state in the union. Whether they recognize our permit or not, we recognize every concealed carry permit in the United States in Alabama now. If you come into Alabama illegally with a concealed permit from Alaska, we're going to honor it as long as you work within the law. Now, whether they recognize ours, that's up to them. But the Alabama Attorney General and this bill have basically entered into agreements that we recognize every state's permit, whether they recognize or not. So it's not exactly totally reciprocal. We're a little more liberal with it. And if y'all remember the big major push for gun legislation last year after the terrible deal in Connecticut. And some of these laws that got passed were absolutely crazy. Some states went out and said, we're going to not enforce any laws other than what we've got on the books now. We're going to arrest federal agents if they come into our state and try to enforce federal laws. And they got into a real contest back and forth. A lot of those have been thrown out and declared unconstitutional, but some places went so far the other way from the northern states that tried to basically ban guns, ban ammunition, put $3 a bullet tax on stuff to try to keep people from getting ammo. But the states in the South went the other way. They basically said, and the guy that authored this bill, the first guy that started this, he basically said he wanted to do away with the permitting process and give everybody a gun and mind their own business and let them take care of themselves. Now that would be a Dodge City type attitude. But that's how this started. That first 136 pages turned into 38. You would not believe some of the things that got taken out of this. It's still fairly liberal, but it's a lot better than it was. It's something we can all live with because guess what? That's what we got to do. All right, at this time, we're going to take a break until 7 o'clock. We're going to start back promptly at 7 o'clock. We have drinks in the lobby. The restrooms are that way. If you would, go take care of business, get you something to drink, and be back. But we're going to start promptly back at 7. If you would, make your way back to your seats, please. We're going to start back. And we're going to give away a few door prizes while everybody's getting seated. If you would, please make your way back to your seats so we can get started back.
They can ask you to leave, but if they don't see it, you're not required to, if they see it and they feel uncomfortable about it, they can ask you to take your gun out and put it in your vehicle. But they don't, it's not saying you're not allowed to go in there with your gun. He was just saying, did you hear that?
So why do you even bother putting a sign up on your guys' business, no guns allowed? Why would you bother doing
That
that?
prohibits anybody that doesn't
It's
have
time for
a
another
pistol permit
shameless
from coming in with a
advertisement.
gun. Somebody
Don't
who
forget to take
has
these bags home.
their gun unconcealed doesn't have a permit. That person might not have tried to get a permit and been turned in. You might have somebody who's walking in your door getting ready to rob you. That's why.
Okay, we got a Tommy Black that Tommy Black? Somebody lied.
Come on through.
Tommy Black, are you out back? David Hulsey.
It's a firm. You have it concealed.
There he is.
They don't know it's there, and chances are you're not going to have to use it. But like you always say, it's good to have it. The very place you know.
Wesley Busby.
Someplace like that where
I know that whole
somebody
Busby
isn't there.
plan's up here. I seen him.
But the hospital's gonna be one of the places you're going not to.
Some firefighters from way back right there. Lance Poe.
Rifle or something?
This is rigged. Winston Busby. Winston, help me with some of them votes up there at Henniger if you don't care, since I'm giving your whole family a weather radio.
Oh,
Oh,
yeah. They must have done that right.
yeah. That's why I guess you were signing up.
James Hart. They had James Hart here. Yeah, is that not the DA in Etowah County? James Hart, is he here?
He was, he's gone, or outside talking, smoking.
Tommy Black, come back in. All right, we got 6 more besides these, and we'll give them away after the presentation.
I'll take one of them.
All right, we're right on time here. We'll try to move through this. We had a couple of questions at the break there, which we always do. And feel free, when we get finished, if you want to ask a question, but you don't want to ask it out loud, catch one of us and ask it before you leave here, okay? Because we're going to be here till we get everybody satisfied that they've got the information they need. So if you have a question and you don't want to ask it in front of everybody, when we get through answering questions and everybody's satisfied and we break and you feel like you're imposing or whatever, you're not. We're going to stay here as long as we can answer the questions that you have and try to get the information to you. So we're going back to revoking a permit. The sheriff can revoke a permit for same reasons that it can be denied. That just makes sense. If you apply for a permit and you're okay and you get it, but then something changes and you meet some of that criteria, you've broken a law or something like that, then he can revoke it for that same cause that would have kept you from getting it to begin with. But he's going to have to provide a written statement as to the reasons for denying it. All right, the next page here is a good one. That's a lot of information there, but what that basically says, a person who's denied a permit has 30 days to basically appeal that decision to the district judge. The district judge can rule on that. He can overrule the sheriff, or he can side with the sheriff, and that's it. I think there's one more, but it's a mandamus, but that's something that's probably not going to happen, and that's pretty much have to compel somebody to do something that they're supposed to do, and under this situation, they're basically doing what they under law were just to do. So that whole big thing right there basically gives you the appeal process to the district judge. The district judge hears the appeal, and he makes a ruling, and then down at the bottom there, you'll see pursuant to state or federal law. That phrase is still in there, and at the second line from the bottom of it, that anything that would endanger the person's self or others, that can come into play. So if somebody's having a bad day, gets into trouble, their permit can be revoked, it can be reinstated, if the situation arises, but that's gonna have to be something that's gonna be a special circumstance. So you do have an appeal process now. Under the old law, the sheriff was under a may issue instead of shall issue, so if he denied you, he is basically denied you. Now he has to either give you a permit or tell you why you're being denied. All right, next page there. Within 30 days of receipt of the appeal, the district court shall review the appeal and issue determination. And if they issue the favor of the person who's permit denied, the person shall be issued a permit or it will be reinstated. And it's going to say by order of the district judge. On the next page there. Nothing in this section shall be construed to permit a sheriff to disregard any federal law or regulation pertaining to the purchase or possession of a firearm. So it is in the state law that the sheriff cannot disregard federal law. He has to follow federal law. And he has to be aware of what the federal law is to follow. So that's the burden that's put on the sheriffs now to not only enforce state law, but they have to actually follow federal law also, because they required them to either give a permit or deny it. So they gave them a fallback here on the federal law. The license permit shall be written in triplicate. That's a lot of stuff there that you can read for yourself. It basically tells you what we have to do with the permits, how we have to file them, how long we have to keep them, what we have to do with them. And that's not something that a lot of you care about, so we'll move on to the next thing. The amount of the fee for a period of 1 year up to 5 years shall be the amount of the fee as prescribed by local law. And if you don't know, there's no provision in Alabama that says a pistol permit, which is a concealed weapon carry permit, is a set amount of money. They're all local bills per county that they get passed, and that's how the numbers are different. So if you get a local bill passed, then it is state law, and that's what the sheriff had to get done here 6 years ago. Pistol permits were $25. He could not give you a pistol permit or sell you one for less than $25. It was state law. It was a local bill, but it was state law. So Judge Taylor actually drafted that, got it put through, got it passed, and we had to charge the dollar because that was an issuance fee. You can't give something for nothing. So we had to charge at least $1, and that's what the sheriff said. We're going to charge what we have to, no more, no less. So the dollar permits, we lose about 40 to 70 cents depending on how many of them we sell. But we sell them, we don't back up on that, and I encourage everybody here that doesn't have a permit to get one if you're able to get one. It's just one more thing that you can fall back on as a defense mechanism if you get in a situation where you're trying to explain yourself or why do I have a weapon. But that's strictly up to you. You don't have to get a permit, but if you don't have a permit, then you better carry legally. Okay? Persons prohibited. This is right out of section 922 of 18 U.S.C. U.S. Code, commonly referred to as the Brady Bill, the Brady Act. James Brady was the press secretary for President Reagan, who was shot at the same time that President Reagan was shot. And they got a lot of gun legislation in the process of being passed, and they eventually got the Brady Act passed. So now this is a condensed version of the Brady Act. If you want to look it up, it's 18 U.S. Code, Section 922, Unsafe and Unlawful Acts, under the Firearms Statute, which is Chapter 44, I believe. So if you want to look at the next page there, you'll see under federal law, a while ago we had state law. The 11 things under state law you could be precluded from having a permit or having a weapon. These are the 9 federal guidelines that we have to go by also. The first one being, having been convicted in any court of a crime punishable by imprisonment of a term exceeding 1 year. A year and a day is a felony in Alabama, is it not, Mr. District Attorney? So exceeding 1 year would be a year and a day or more. So that basically in itself says a felony. You cannot have a weapon. Number 2, a fugitive for justice. That makes a lot of sense. Every time I legally buy a gun in a gun store, that I have to mark that box that I am not a fugitive from justice. And I'm not an illegal alien here unlawfully. But I have to fill that out because guess what? That's a legal document, and if I falsify that document, I can go to prison. And it's not a state charge. So a fugitive from justice cannot possess or own a firearm. An unlawful user of or addicted to any controlled substance. That's broad also. What constitutes an unlawful user? If you've been arrested on a drug charge, then guess what? You're an unlawful user. So if you're an unlawful user or addicted to a controlled substance, you're precluded from having a weapon under federal law. Adjudicated as a mental defective or committed to a mental institution. Well, that's just common sense. Those people don't need a gun. They're a threat to themselves as much as anybody else. But that is adjudicated, which means by judicial order or decree, they have been determined to be mentally defective. An alien illegally or unlawfully in the United States. Well, that's a no-brainer there. You can't have a weapon if you're here illegally or unlawfully. That's federal law. If you've been discharged from the armed forces under dishonorable conditions. And I've had some people say, well, what about less than honorable? That's not a dishonorable discharge. There are several different discharges. This says under dishonorable conditions. Specifies that. If it's less than honorable, then there's a reason for that. That may be something else to look at. But dishonorable discharge from the armed service is definitely get you out. Having been a citizen of the United States and renounced your citizenship, subject to a court order that restrains the person from harassing, stalking, threatening, or an intimate partner or a child of such intimate partner. These are our, what we refer to, protection from abuse, a restraining order, because you've got people that are fighting. If they're fighting over a kid, if there is a court order in place, then you're precluded from having a weapon, even in your possession, under federal law. And the last one there, been convicted in any court of a misdemeanor crime of domestic violence. So that's a misdemeanor charge, but it still precludes you federally from having a weapon. Section 3, we're going to go through that pretty quick. That deals with gun shows, the fees that are required for gun shows, the record keeping and stuff. I don't think a lot of you have a problem with that. If you want to ask some questions about that, we'll take those at the end. But Section 3, we're going to basically just go through that, skip over that, because that tells what you have to charge so far as permitting gun shows, the records that they have to keep, and that's not something that we're going to deal with. That's a business license issue or a city enforcement officer issue if they've got a gun show. The last page there, Michael, all persons dealing in pistols, I think is page 22. You can go to that. All persons dealing in pistols, revolvers, and maximum silencers shall be required to keep a permanent record of the sale of every pistol, revolver, silencer, showing the date, serial number, identification marks, manufacturer's name, caliber, and type, and also the name and address of the purchaser. So that's just record keeping. Section 4, restrictions on firearms on business property. This is what a lot of you are interested with. Employer rights as they relate to firearms. We're not going word for word with the state law here, but if you pull up the act and go to Section 4, this is all in there, and I can tell you where to look for that if you need to in the law itself. But we're going to basically condense this down and hit the high spots here. This provides that an employer can prohibit employees from carrying firearms on their persons while the employer's property are doing their business. In other words, if you work for somebody and they tell you you can't drive the company truck and have a gun in it, you can't have it on your person while you're working for me, they can do that. If you want to work for them and keep working for them and they tell you you can't have a gun on company property in the workplace other than the parking lot, but I'm talking about in the workplace while you're working, if you're traveling, if you're driving a truck, if you're going from point A to point B, and they tell you if you're going to work for me, you can't have a weapon on you, a firearm particularly, then you can't have it. This gives them the ability to take adverse action against you if you violate that. So, if you can't have it on your persons, where can you have it? It also prohibits an employer, public or private, from prohibiting an employee from transporting or possessing a firearm or ammunition in the employee's vehicle while parked in a public or private place. So if you can't have it on your person while you're doing the work, can I bring it to work in my vehicle? Before, you couldn't. Now, if, and you'll see if, where it says parking area if. And then you start having some criteria here, where you can bring a gun to work in your vehicle if it's loaded, if it's properly put up. But you have to meet all this criteria right here. So you start looking. First thing, a valid concealed permit. So if you go to work at Howell and you go in there and you have a permit and you got a loaded weapon in your truck, and I just use Howell because it's a big employer that everybody pretty well knows around here. I'm not picking on Howell, I'm just saying, if you go to the Howell and you park in the parking lot, which is open to the public, they come in there and park, and then they go in the plant. And the people at Howell say, you cannot bring a weapon in here while you're welding. You can't do that. You can't take a weapon in there and weld. But if you come to work with a loaded gun in your vehicle, and you've got a permit, and you follow the rest of this criteria, you can do that. So you look at all the criteria. The first one there is a concealed permit. Or the firearm is one legal for hunting and is not a pistol. And the employee has a hunting license and the weapon is unloaded and is during a hunting season. And the employee has never been convicted of a crime of violence and is not subject to a protection and abuse order, and the person does not exhibit any of the listed reasons why the sheriff can reject him on permit, and the employee has no documented prior workplace incidents threatening physical injury or resulting in physical injury, and the vehicle is parked and operated only where it's permitted to be, and the firearm is in a motor vehicle attended by the employee and kept from ordinary observation. And if it's kept from ordinary observation, what is it? It's concealed. It's kept from ordinary observation, and locked in a compartment, container, or in the interior. So if you meet all that criteria, you can have it in your vehicle. So you got to meet all of that. That's why it keeps saying, it don't say or, it says and. So if you meet all that criteria, then you can have it in your vehicle in the parking lot, but you cannot take it into the building or use it in your pocket at work or whatever. If they prohibit you from doing that, you have to follow those rules. If the employer believes an employee presents a risk of harm to himself or others, he can inquire whether the employee has a firearm in his vehicle. If you've done something to raise alarm at work and they're fearful that you may get into it with an employee after work, they can come to you and ask you, do you have a weapon in your truck or your car, whatever you're driving? And if the employee has a firearm in the vehicle, then the employer can inquire whether the employee is in compliance with the law. In other words, they can ask you if you have a weapon, and then they can ask you, do you legally have that weapon in your vehicle? And if they meet all this criteria, okay. But if they don't meet that criteria, then they can take adverse action against you. So you have to meet all of those listed above there, the major 3 bullet points there. If the employee is not in compliance with the law, then the employer may take disciplinary action. So if you legally have it there, they can't take disciplinary action if you've legally got it there. If you don't have it legally there, they can take adverse action, disciplinary action. An employer may not take disciplinary action against an employee based solely on the presence of the firearm if it has been in compliance with everything in Section 4 legally. They can't take adverse action. So that's state law now that gives the employees some rights at work. If an employer takes disciplinary action against an employee based solely on the presence of the firearm and the employee complies with this section, then the employee can sue for wrongful termination to recover lost wages and earnings. So the employee has some rights now. Section 5. This provides immunity for employers and property owners based on employees bringing firearms onto the property. It basically says that the presence of a firearm does not by and of itself constitute a failure to provide a safe workplace. In other words, if the people at Howell prohibit you from bringing weapons into work, but you legally have them in your vehicle like you're allowed to do now, and somebody, God forbid, does get into it after work and they take their gun out and shoot somebody, then they're going to get sued, but this gives the employer a little bit of liability protection here because they don't have a duty to patrol the parking lots, search vehicles, and keep people from doing stupid things. They're an employer, not a babysitter. So this gives them just a little bit of immunity, but anybody can sue anybody any day for anything, but this gives them a little legal standing if they are sued, okay? So the employers get some legal help here as well as employees. One of the big ones here, Section 6. This is one we get most of the questions on. This provides that no one may knowingly possess or carry a firearm in any of the following places without the express permission of a person or entity with authority over the premises. In these first four, you can't carry a firearm in there even with a permit unless you're law enforcement. You'll see the first one is inside the building of a police, sheriff's, or highway patrol office. You cannot carry a firearm in there even with a permit. Second, anywhere on the premises of a prison, jail, halfway house, community corrections facility, or other detention facility for those charged with or convicted of criminal or juvenile offenses. So you can't even with a permit carry a weapon in there. Number 3, anywhere on the premises of a facility which provides inpatient or custodial care of those with psychiatric, mental, or emotional disorders. So if you've got a local hospital that has a psychiatric wing, then guess what? You can't go anywhere in that hospital with a weapon, even with a permit. Number 4, inside a courthouse annex, a building in which a district attorney's office is located, and they had that specifically put in there, or a building in which a county commission or city council is currently having a regularly scheduled or specially called meeting. If they're having a meeting, I want you to understand that. If they have a county commission meeting regularly at the activities building on the second and fourth Tuesday or whatever, you cannot go in that building if a meeting is in session with a firearm, even with a permit. If the commission meeting is not in session, then that takes that part of it out. But if the building is posted, no firearms allowed, then what? Don't go in there with a firearm. But if there is a council meeting, a city council meeting in session, and it can be either regularly scheduled or a specially called meeting, then you cannot take a weapon in there, even with a concealed permit. County commission, those are specifically addressed in number 4. Then we get to number 5 and 6 here. Number 5, inside any facility hosting an athletic event not related to or involving firearms, which is sponsored by an elementary or secondary school or post-secondary institution, unless the person has a permit. They threw that last little phrase in there. So can I take a gun to a high school football game if I've got a permit? This says I can, unless I have a permit. But guess what? Here's the one that throws that one out the window. It's against federal law to take a firearm within 1,000 feet of a school. 1,000 feet from the furthest building is considered a school zone. So if you go to the longest, furthest building and go 1,000 feet from the corner of it, that's a school zone. It's against federal law to have a firearm on school property, on a school zone. So it's not in the building, it's in a school zone. So 1,000 feet from every building. A lot of the schools are posting that now so that they also meet the state requirements. There's a provision in here that you can't take a firearm into a place where it is normally regulated during normal business hours and it has a guard or surveillance system or something to keep you out. The principal is considered the guard in a lot of schools. So if it's posted, don't go in there with a weapon. It's just common sense. Now, what do you do if you take a weapon onto school property and you have a permit and somebody tells you, hey, you got to go put that up? Better go put it up. If you don't, they can have you arrested for what? Criminal trespassing. It's a violation. It's not a misdemeanor or felony. It's not a gun charge. It's criminal trespass because they asked you to leave and you didn't. Okay? Now, if you go to the school to pick up your grandkids and you pull in the front driveway and you got a permit, you got a gun in your pocket, am I illegal? Yes, you technically are. Am I going to arrest you? I don't know you got a gun in your pocket, but if something happens and we find out you got that gun, you could be, under federal law, prosecuted. I'm not going to arrest you for a federal gun charge, but that doesn't mean if you get into something on school property and you got a gun in your pocket and you get arrested or you get hurt and you go to the hospital and they find a gun on you, somebody somewhere is going to make an example out of somebody in federal court over this, folks. You get ready for it. The Attorney General of the United States is going to make an example out of some of these good old boys that carry guns where they don't need to have them over something that accidentally happened or whatever. So the bottom line is, do you need to take guns to school? No. Do you need to take them to church? No. Do some of us? Yes. If you have a firearm, do it legally, do it safely, and do it responsibly. Try to follow the law as much as you can. But the next one here is number 6, inside any facility, hosting a professional athletic event not related to or involving firearms unless the person has a permit. That also depends on whether the property is posted, whether it's school property, or whether there's a federal prohibition to keep you from having that weapon there. If you, in your own thinking, go through this process and say, if I go there and I've got a permit and I carry my weapon, could I get in trouble? That's probably when you need to back up and say, I don't need to even draw attention to myself. It's not worth it. Okay? So if you think you might get in trouble, then use some common sense here. It also requires the person or entity with authority over the premises listed above to post a notice at the public entrance that firearms are prohibited. And you'll notice in your handout we gave you 2 signs. Firearms are permitted, firearms are prohibited. And those are just something that you can take and make any way you want to. You can handwrite them. Those are by far nothing that we want you to go out here and just start putting on doors over. That's just something to tell you if you're going to do it, try to follow those guidelines a little bit. You can go so far as to put law enforcement exempt from this prohibition, but you don't have to do that because we are exempt from that anyway. If we're officially doing our job, we can carry firearms even if it's posted. So you don't have to put that exemption on there because law enforcement knows they're exempt. And that, to be honest with you, just makes some people mad when they see that. Well, why can a cop come in here with a gun and I can't? So take that argument out. And you post it any way you want to, but if you're going to post it, try to post it right. And like the district attorney said, if you've got a business or a commercial operation or whatever, talk to your legal counsel and get guidance from them before you do anything. I know one of the major bank chains here in town, they as a corporate decision said we're not going to do anything right now. We're just going to see if it becomes a problem. And if it does, then we may post our banks. But they're not posted right now. You walk in there with a gun strapped on, if it doesn't pose a problem or nothing gets out of hand, they're not going to try to make an issue of it. But if they say that it is an issue and they post it, then you need to leave your weapons in your car. If it's posted, don't take it in there. It also requires that firearms on the premises listed above must be kept from ordinary observation and locked within a compartment or in the interior of the person's motor vehicle or in a compartment or container securely affixed to the motor vehicle. No one may carry a firearm inside any building or facility to which access of unauthorized persons is limited during normal hours of operation by the continuous posting of guards. And I know we've had this discussion before. What constitutes a guard? That's a very broad term. A guard could be considered somebody just standing there looking at the door. It could be a receptionist right inside the door. If there's one way in and one way out for the public to go into a school, then that's limited access, and they're prohibited if it's a school. But if it's a business and you have a security guard and the building's posted and somebody comes in, then you can ask them to leave. If they refuse to leave, it's criminal trespass. It's not a gun charge, it's criminal trespass. It's the only charge here. We're not going to go out here and just arrest people for having a gun. We're going to arrest them for violating the law. Just having a gun is not a violation of the law. It has to meet certain criteria. All right, possession of a firearm in violation of this is a Class C misdemeanor. That's the maximum of 30 days and a fine. This does not prohibit any person from possessing a firearm in their residence or during ingress or egress, coming or going from your home. You can have a weapon. You can always have a firearm on your own personal private property. This does not apply to law enforcement during their official duties. Section 7. This basically says that the regulations as set forth in this state go to the state. The Attorney General has the ability to bring suit, settle disputes, and takes it out of a lot of the smaller venues. So Section 7 basically says the state of Alabama is going to enforce this, and they're going to bring suit if the suit needs to be brought. And it also has over on the next page there, 29, the Attorney General will file a suit or publicly state in writing what his justification is for not filing suit if a situation arises. And nothing in this statute prevents any of the following. And you can look at the list of things there, 12 things I believe, that nothing in this statute prevents you from doing anything. And the second one there, like the first one, it says, nothing in this keeps a sheriff or a police chief from regulating what weapons his people carry or what ammunition they use. They still have the right to regulate that by their own policies. An employer from regulating possession of firearms by its employees during and in the course of their official duties, they can still prevent that. The prosecutor from hearing a case doesn't prevent that. Any political subdivision from enacting or enforcing rules for a firing range that it operates, they can still do that. So there's a lot of things here that you can still do and not be contrary to state law. It doesn't keep a political subdivision from conducting a firearm-related competition or an educational, cultural program. It doesn't keep any political subdivision from enforcing laws passed by the legislature. And what we mean there is, if a municipality wants to take this state law and adopt it as an ordinance, then they can enforce it as a city ordinance within their own city court system, but they have to do it word for word. They can't do anything. They can't pick and choose the parts of it they want to enforce. It has to be in total. It has to be word for word. Section 8. This is what a lot of people are interested in as much or more than anything else. The self-defense law. Alabama's so-called stand your ground law. We know all the stuff going on in Florida right now about the stand your ground, and how does that apply to me? We've tried to simplify this. If you will look at those two major bullet points there. Alabama self-defense law says that a person can use deadly force if the person reasonably believes that another person is using or about to use physical force against an owner, employee, or other person authorized to be on business property when the business is closed. If somebody's closing up at night, one of the employees is closing up and somebody tries to come in there and break in or rob them, they are now justified to use deadly force to stop that if they feel like they're in imminent danger. So this is taking some of the stand your ground stuff from your house and put it out to your place of business and one other place. Y'all know where that is? Your vehicle. An occupied vehicle. The castle doctrine has been discussed for years, and it basically says, my home is my castle, that's as far as I can run. If I'm not safe there, where else can I go? I have the right to defend myself in my castle, but where does my castle go? Where's the boundaries? So pretty much what Alabama law now says is your castle, as far as defending it with deadly force, can extend to your business if somebody tries to do the same thing in your business that they would be doing at your house, which would be the things that look like here, like robbery, kidnapping, trying to forcibly remove somebody. If they do that at your place of business, when it's closed, then you can use deadly force. You can use deadly force anytime you feel like you are in imminent danger of serious bodily injury or death. But this specifically says your place of business, and what this was pretty much to address was business owners getting robbed or burgled, disturbing a burglar, and turning into a confrontation and having to shoot that person to defend themselves. Now they basically have that ability to use deadly force even at their place of business when it's closed. Okay? And then the second thing there, it adds business property in two other places. defending with deadly physical force if the person uses force that that other person believes in the process of unlawfully forcibly entering or has unlawfully or forcibly entered, or is attempting to remove or is forcibly remove a person against his or her will. So if any of that's going on, you are authorized to use deadly force. If you are in your vehicle and somebody tries to take your vehicle, carjacking, if they try to pull you out of your vehicle, steal your vehicle, assault you, you are authorized to use deadly force. That's an extension, and it says specifically occupied vehicle. You can't shoot somebody for stealing your pickup truck out of the yard. You've got to be in fear of their life. Okay? But if you're in your vehicle and somebody tries to carjack you, you are allowed to use deadly physical force. I know that's going through this quick, but if I did it any slower, you'd all be in a coma. Like I said, this is 38 pages of the law, 55 pages of one analysis, 58 pages of another analysis. At this time, we'll give away some more door prizes, and as soon as we get through with that, we will take questions. So as soon as we get through with the door prizes, if you don't have a question, you're free to leave, but if you'd stay in your seat just a few more minutes, we'll give out the rest of these weather radios, and then when we adjourn, those of you that want to leave can do so. If you want to stay and ask questions, just stay in your seat, and as soon as everything calms back down, then we'll start taking questions.